House Committee substitute for House Bill 1374. I see Chairman Cox in the audience. Chairman, welcome.
Thank you, Mr. Chairman. Don't really have a long presentation, but I'm Stanley Cox from the 52nd District. This bill is identical to Senate Bill 706. As I understand, it actually passed the Senate. It's the patent control legislation. And never did I ever imagine I'd file a bill that I would use the word troll in order to file it. But I'm going with the flow on that. Mr. Chairman, certainly answer any questions you all might have.
Are there any differences between this legislation that you're presenting the legislation that we...
I understand it is identical.
Okay. Are there any questions for the sponsor, House Bill 1374? Do you have any witnesses?
I think there are.
Okay, those in favor?
Mr. Chairman, member of the committee, my name is David Overfelt. I'm the president of the Missouri Retailers Association, and I'm also a lobbyist for the Missouri Grocers Association and Associated Industries. I work on environmental issues. Tonight, Associated Industries wanted to put a witness form in favor. They had not done that before, but they did favor the third read Senate version, Senate Bill 706. It had some other things worked out in it, some language, and so they did want to go on record, but the version was the third read Senate Bill 706. Of course, the retailers and grocers were in favor of both originally filed bills, and we worked with all the parties, including the Associated Industries, to compromise this, so we hope to get it passed before the session ends.
Okay. Any questions for the witness? Thanks very much for your testimony.
Let me correct the record. There is a different version that was passed in the Senate. I'm certainly happy with it and consistent with the
Okay.
identical changes being made.
Okay. Yes, absolutely.
I'm sorry, Representative, I was in the hallway there. What's the difference between this and the Senate, do you know?
I have seen it only in passing, and
Is it substantive, or is it,
but I think there are witnesses might be able to tell you. So.
Okay. Thank you.
I don't have the language changes in it, but most of the Senate will remove some sections. So,
Thank you very much. Anyone else who testify in support of House Bill 1374?
Good evening, Craig Overfeld with the Missouri Bankers Association, and we support House Bill 1374. The Senate substitute that passed had a different, revised definition of target on page 1, and everybody that's been supporting this bill favored that change. The other version that was out there was a little too general in nature. Trying to find some balance here between people that have legitimate patents and those who are filing these phony demand letters, which is what our real aim is here. On page, let's see, I think the right version out. There was a couple of terms in here on page 2 of the House Bill, subsection 416 and 652. Sub 2, sub 6, and 7. We removed those at the request again of some companies that thought that was a little bit too vague. The word vague and meritless. Some of these things are pretty unclear, and these companies that do have to fight these legitimate patents wanted that removed from the bill. Nobody saw any problem with that. And under the private cause of action, there was a section that was taken out also, 416, 654, sub 2, that if there was a defendant willfully and knowingly violated 415, 652, the court could award not more than 3 times, which is 10,000 times 3. None of us felt like that was a real big issue for us either. So the bill still strikes a good balance between trying to to deal with these demand letters and those who have the legitimate pets. Those are the primary changes, and we're all in support of all those changes that the Senate made.
Okay. Any questions for the Swifters? Thanks very much. Anyone else speak in support?
Mr. Chairman, members of the committee, I'm Brent Butler with the Missouri Insurance Coalition. I'm not an Overfeld, and I hope you let me speak.
Any questions? Thank you very much. Any other witnesses?
David Kim with the Missouri Credit Union Association. We also support this bill. I want to thank the senator for sponsoring the bill.
Thank you.
Chuck Pierce, representing the Missouri Society of CPAs. We just want to go on record.
Thank you very much. Anyone else to testify in support? Anyone to testify in opposition? Anyone in opposition? Okay, I'll close the hearing on House Bill 1374.
Thank you.
Thank you. We'll now open the hearing on House Bills 1307 and 1313 for Senate development.
Evening. Good evening. Thank you, Mr. Chairman, members of the committee. This bill, I think you may have heard before. It was originally filed identical to that Senator Sater had presented, changing the waiting period from the time that a woman gets an exam until the time that she goes back in to have the abortion performed, to extend that waiting period from 24 to 72 hours. One other change that I would draw your attention to is that in the House, on the House floor, the bill was amended to also include that there be a video production of the information that is presented to the woman at the time of her examination, and that she would have to view that video presentation of the information. One of the arguments that was made for that occurring was the fact of how much information is given to these potential mothers, and it may be better sufficed and summarized if they had it in video form, or that they could watch it at the time of their examination. So with that, I'll yield.
Okay. I'm going to pause for a moment so that we can take roll.
Senators Dixon. Here. Emmer. Justice.
Here.
Ewing. Here. Shaw. Here. Schaefer. Lynch.
Okay. Moving on to the full committee. Are there questions for the bill sponsor? Okay. Do you have witnesses to testify in support?
I think there are a few.
Okay, those that would like to testify in support, please come forward at this time.
Mr. Chairman, members of the committee, Joe Artworth with the Missouri Family Policy Council. Mr. Chairman, I'm not going to recount the testimony that was shared previously with this committee when the bill presented by the gentleman, Senator from Berry, was before you. I just want to thank you for your favorable consideration of that proposal and ask for your continued support of this proposal. The Supreme Court has made very clear that legislation like this fits within the constitutional framework that they've established, in which states are allowed to demonstrate their preference for childbirth. To do that through an informed consent process that allows the woman to carefully reflect on the options before her to make the best decision for herself and her child. Happy to answer any questions.
Okay, are there any questions? Okay, thank you very much. Anyone else?
Mr. Chairman, members of the committee, for the record, Susan Klein, representing Missouri by July, here to go on record House Bill, in support of House Bill 1307, and I won't repeat the testimony on Senate Bill 519 as well as this in this witness.
Any questions? Thank you very much.
Thank you, Mr. Chairman, members of the committee. Samuel Lee with Campaign Life Missouri, who's on record in support of House Bill 1307 and 1313. And just testimony that we had on the Senate bill would apply to this bill also. I would say that the language, regarding the language that sponsor was added on the House floor by another think in concept is good. However, I think it would need to be reconciled a bit by this committee or somewhere in the process. It requires the department to develop a video of all the information, all the informed consent information, and explicitly excludes just one piece, which is the physician's name. And I really think that there are other aspects of the informed consent that would not be appropriate to be in the video, or as a practical matter, would not be in that video. There's a requirement that her particular medical condition be discussed, and the gestational age of her unborn child, as well as other types of information like the hospital that the physician is on staff of within 30 miles. And as a practical matter, I think that could not be in this type of video. So I would suggest that maybe this language needs to be changed a little bit, and also that it be permissive and not mandatory. To me, it's unclear as I read the placement within this section, whether the video would be mandated that she view it. I think that could be problematic if that were the case. I'm not saying that it is. I think it's one of those questions, but I think it's something that could be worked a little bit and massaged a bit. And then another idea would be to even require the department, if they're going to make a video, which will be shown there, is to make copies for the woman to take with her. Right now, the Department of Health and Senior Services puts together the informed consent printed material, and there's no reason, if they're already going to be making a video which would provide the general information, then just go ahead and make some DVDs, and if the woman requests that to take that home with her during the 72-hour waiting period, she could watch it again, she could share it with her partner, with her family members, things like that. Those are just a few suggestions.
Thank you. Senator Justice.
Sam, would you be willing to act in this video that we're going to shoot?
You know, I don't know. That's it depends what role you have me in. I don't want to, it's
Just keep that in mind.
okay. I don't know if I'd be very good in the doctor's office.
That's always so short.
But thanks for asking.
Any other questions? Thank you. Okay. Anyone else who testify in support?
Thank you, Mr. Chairman, members of the committee, Tyler McClay, General Counsel of Missouri County Conference 20 record support. Also want to comment on the video portion. I think the intent of the representative was that this could be offered as an alternative way for women to receive the information. As I read the statute, it would be mandated that she see the video. I think that could be a problem. I think it would be a problem.
Any questions? Thanks very much. Anyone else in the audience that wishes to testify in support? House Bill 1307 and 1313. Anyone to testify in opposition?
Good evening. My name is Ryan Summerford, and I'm the statewide manager of government affairs for Planned Parenthood Advocates in Missouri. I'm here to submit testimony in opposition of 1313 and 1307. Similar to the supporters of this bill, I also submitted testimony in this committee earlier this year on 519, and I would also refer and reflect back to that testimony. In addition to that testimony on 519, I would like to again point out that what this really is an attempt to shame and coerce women away from getting an abortion. To put in a 72-hour mandated waiting period for non-medical reasons, for political reasons that are meant to shame and judge a woman for her decision to exercise her constitutional right for abortion services is wrong. And Planned Parenthood is in opposition to 1313 and 1307. In addition, the requirement for the Department of Health and Senior Services to require a woman to actually view a video is duplicative. I brought with me to share with the committee the 26-page color booklet from the Department of Health and Services, which is the informed consent booklet, which each patient has to go over both verbally and in writing with the certified medical physician. So not only is the woman getting this information from this booklet in writing, not only is it being gone over with a qualified certified medical professional, but she is also given these informed consent information verbally and in writing, and to have a third kind of shaming to make them sit through and watch another video is duplicative, and we're against that. Again, if the purpose or intent of this bill is to reduce the number of abortions, nobody does more than Planned Parenthood to make sure that happens. We should be, instead of shaming women for their choices, we should be supporting them by providing them with sex education and contraception services, which 90% of what Planned Parenthood does is preventative services. And with that, I'll stay for any questions.
For questions at this time, any questions? Thank you very much. Anyone else in the audience that would like to testify in opposition? Anyone else to testify in opposition? I think that will close the hearing on House Bill 1307 and 1313. Thank you, Representative.
Thank you.
Now, open the hearing on House Bill 1192. Representative Miller.
Thank you, Chairman, members of the committee. Thank you for allowing me to bring this House Committee substitute before you. For the record, I'm Rocky Miller, representative from District 124, Lake of the Ozarks area. House Bill 1192 is a common sense bill. Currently in Missouri, a custodial parent is notified of every medical action taken on behalf of a minor child, with the exception of one. It takes one custodial parent to allow an abortion to be performed on a minor child in Missouri without any notification to the other parent. This bill will require that both parents must be notified 5 days prior to the medical procedure. The intent of this bill is to keep all parents aware of medical procedures being performed on their minor children. In addition, I have added that if for some reason a parent still has custodial rights after being convicted of abuse, that parent may not be notified. In addition, I had a witness that she's an accountant, and as you can imagine, today she's very, very busy. However, she did give testimony in the House hearing that said she's very much for this bill. When she was 15, she was taken to have an abortion by her mother without the consent of the father. 3 months later, her father found out about it, wept, and told her that they would have done anything to help her out. She wished there was such a bill so that at least that discussion could be had at that time. She says she looks at her 3 children now and realizes there should be a 4th. And so that's one of the main reasons to have this bill. In addition, part of the bill was added on to, it has Representative Gatlinburger's First Amendment protection for alternative to abortion agencies. If there are no other questions.
Yes. Representative, is that part of the board? Is that the, oh, I see it.
Page 3 and 4.
One question I have is, you mentioned the 5 days prior.
Yes.
Is that, I didn't get a chance to go over this in detail before the committee here. Is that consistent with notification currently?
Currently, further in the bill, there's notification when it has to go before a judge, and 5 days is the standard there. So I just took that 5 days from there.
Questions of the sponsor? Okay. Are there witnesses here that would like to testify in support of House Bill 1192? Anyone to testify in support?
Thank you, Mr. Chairman, members of the committee. Once again, this is Tom representing Missouri Right to Life, here to go on record in support of House Bill 1192. And the sponsor explained it very well. Really, it's just extending the parental consent into parental notification as well. Custodial parents, so the court has recognized these parents to be able to be access their children and have their children with them. So, and the clause that is included in the bill that would not allow them if they were abusive parents, that protection is there in the bill. And we also support the section that gives protection to the great work that the PRCs do, that they will not be harassed.
You might
that's what he took.
Okay.
So,
All right, questions for the witness? Okay, thank you very much.
thank you.
Thank you, Mr. Chairman, members of the committee. Samuel Lee with Campaign by Missouri, go on record in support of House Bill 1192. Just a couple of things, not to be duplicative. On the language on page 3 and 4, dealing with the First Amendment rights of pregnancy care centers, that is verbatim the language that Senator Wallingford has had as a bill before this committee, and which this committee heard and voted on in favor of due pass last year, and also Representative Gatchenberger's had previously in previous years in the House and passed the House. And that was added as an amendment on the House floor. Regarding the 5-day, the notification within 5 days, I guess I guess the concern that I would have is not with the law, but how the courts would look at the 5 days plus the 72 hours added together, the 3 days. And just in looking at other cases in other jurisdictions, you start having no magic number of days, but the type of challenge that plaintiffs will make will be, this is unduly burdensome. And I can't say what that magic number is, but oftentimes these complaints will be structured in such a way that it's, well, it takes this many days for consent and this many days for informed consent, and you add in weekends and holidays, and what do you get? And you end up with 8 days, 10 days, 12, whatever they come up with. And that's always a concern of how the courts are going to deal with that. And I don't have a clear answer. I will tell you this, if you have a 2-parent consent, this is a 1-parent consent and 1-parent notification, which no other state has. If you were to have a 2-parent consent, and there are 3 states that have 2-parent consent, Mississippi, North Dakota, and Kansas. There is no, because there's a consent, there's no time period that you have to notify somebody. Either you get consent or you don't get consent. And of course, the young woman always has the option of going to court, to juvenile court, which the sponsors pointed out. I'm just raising this with you because if we're talking about passing the 72-hour waiting period bill and passing this bill, and there's a court challenge, and we're relying on the Attorney General to defend it, where do we end up? And I think there are ways around that. Either you can reduce that period of time, you could require 2-parent consent, which has been upheld. Mississippi, their law was specifically upheld by the 5th Circuit, and they have 2-parent consent. You can go a lot of different ways. But anyway, I just want to sort of raise that issue, but in complete support of the bill.
Thank you. Any questions for the
And Mr. Chairman, I'm going to leave with you from Guttmacher Institute. They have sort of a rundown of the state laws on consent notification if you want to delay to those.
All right. Anyone else testify in support?
Mr. Chairman, members of the committee, Tyler Clay, General Counsel, Missouri County Council, hold on record in support of House Bill 1192.
Okay, anyone else to testify in support?
Mr. Chairman, members of the committee, Joe Artworth with the Missouri Family Policy Council, we'd like to go on record in support of this proposal.
Okay. Thank you very much.
Thank you.
Anyone else to testify in support? House Bill 1192. Anyone to testify in opposition?
Good evening again. My name is Ryan Simmerford, and I'm the statewide manager of government affairs for Planned Parenthood Advocates in Missouri. I am here to put in my testimony in opposition to Senate or House Bill 1192. First and foremost, I think that we all want our teenage daughters to be safe. I think that we all want young girls, when they're faced with an unintended pregnancy, to go to their parents and to talk about all of the options that they have available, including adoption and including carrying the child to term. Unfortunately, in the real world, not all families are perfect, and not all families have that communication where they can talk about some of these things. in the current statute, there is one parent-informed consent process that is there. And from representing an actual abortion provider, those informed consent process with that parent is taken very seriously. The parent has to stay with the minor at all times. There has to be photo IDs for both the parent and the minor. If their names or addresses are not the same on those photo IDs, additional state documents, including birth certificates and or marriage or divorce decrees stating those names, have to be verified before an abortion procedure can happen. So there are safeguards in place to make sure that those young women who do choose the abortion have that parental involvement in place. The additional 5-day waiting period does create an undue burden, because what we know is when young teenage girls are faced with obstacles and confusion, they're going to be more likely to put off talking to their parents about the pregnancy. They're going to be more likely to go across state lines, to do unsafe methods that would hurt their health. So while on the surface, 1192 does look like it is protecting our teenagers, the unintended consequences is that there could be many girls who reach for unsafe methods to try to hide their pregnancy and to terminate their pregnancy themselves. So for that, we are against House Bill 1192.
Thank you for your testimony. Any questions for this witness? Thanks for that.
In addition, I do want to leave some additional testimony from Pamela Sumners from NARAL Pro-Choice Missouri, who is unable to be here. I filled out a witness form and have attached her written testimony.
I will distribute that to the committee. I cannot enter into the actual records since she wasn't here, but we will distribute it to members.
Thank you.
Give her my regards. Thank you. Anyone else to testify in opposition?
Good evening, Mr. Chairman, members of the committee. My name is Crystal Williams. I'm here representing the American Civil Liberties Union, Missouri. We'd like to be on record as testifying against this legislation, largely for the reasons that were just stated. I do think that when you had the discussion also with Mr. Lee, and we're talking about the different potential obstacles in court, that would be one of the reasons that we also oppose it, because those obstacles do exist. And the undue burden standard is the reason for that.
Any questions for this witness? Thanks for
Thank you.
testimony. Anyone else to testify in opposition to House Bill 1192? Seeing none, I'll close the hearing on House Bill 1192. Representative, thank you very much. We'll now move to House Bill 1245. I see Representative Hampton is here. We'll open that hearing.
Good evening, Mr. Chairman and members of the committee. Thank you for the opportunity. For the record, I'm Representative Kent Hampton, honored to represent District 150, consisting of the central and southern portion of Duncklin County, the southern portion of Pemiscot County, in southeast Missouri, better known as the Blue Heel. And today I present for you House Bill 1245, dealing with duplicate sections of statute, 9 to be exact. Mr. Chairman, I might ask, is it appropriate to do a handout or pass out?
We'll get that for you.
Okay. Thank you. This was a comprehensive effort between the Office of Administration, Missouri House, and Missouri Senate. This bill includes 9 sections contained in more than one bill passed the same year.